Welcome to the 2020 Occupational Health and Safety Act Change Highlights webinar. If you have questions about occupational health and safety, OHS, call the Alberta OHS Contact Centre at 1-866-415-8690. If you are in Edmonton or the surrounding area, call 780-415-8690. If you have questions about this webinar, email lbr.ohsfeedback@gov.ab.ca. After watching this webinar, please take a moment to fill out the short survey and give us your feedback. The link to the survey is on the YouTube page below the subscribe button. Before we begin, we have a disclaimer and copyright notice that we need to bring to your attention. We've done our best to ensure that the information in this webinar is accurate and up to date. However, if there is any discrepancies between the webinar and OHS legislation, the legislation is correct. I'll give you a few moments to read the copyright notice. This webinar is an overview of the 2020 updates to the OHS Act and complements the change highlights, the 2020 OHS Act Bulletin. You can find the Change Highlights Bulletin on the OHS resource portal at ohs-pubstore.labor.alberta.ca. Once you're in the portal, type Change Highlights in the search bar at the top of the page. The 2020 OHS Act eliminates duplication and simplifies language, making the OHS laws easier to understand. Fundamental rights, protections, and obligations remain in place, but with new focus on outcomes rather than processes. The following presentation highlights some of the changes in the 2020 Act. Think about how they might affect you as a worksite party. Radiation legislation. The Radiation Protection Act and its regulations are incorporated into the OHS Act and OHS Code. Alberta has an excellent radiation protection program, and laws governing it will remain intact. The changes are administrative, such as removing duplication, updating wording to align with the Act, and transferring enforcement from third-party agencies to OHS officers. For more information, see the guide for Alberta's Radiation Protection Program. You can find this guide on the Open Government portal. Use the web link on the screen below. The purpose of the OHS Act hasn't changed. That includes workers' rights. The Act ensures workers have the right to know about workplace hazards and access to health and safety information at the worksite, the right to meaningful participation in health and safety activities pertaining to their work and worksite, including the ability to express health and safety concerns, the right to refuse work if they reasonably believe that there is an undue hazard at the worksite or that the work is an undue hazard to themselves or others. The ability to work without being subject to disciplinary action for exercising rights or carrying out duties imposed by OHS legislation. Definitions. There are some changes to the terminology used in the Act. Specifically, instead of being a separate worksite party, self-employed persons are now included with employers. The term contractor is renamed to contracting employer as a defined worksite party. The term disciplinary action complaint replaces discriminatory action complaint, removing confusion with human rights language and laws. In addition, the new Act provides a definition for construction worksites as well as oil and gas worksites. Worksite party obligations. Part 1 of the Act addresses worksite party obligations. Worksite party obligations reflect the internal responsibility system, which is the basis of Alberta OHS legislation. Changes in the Act help to streamline these obligations and improve clarity. The obligations of employers now apply to self-employed persons, with any necessary modifications, of course. Information sharing requirements are now integrated into worksite party obligations, and redundant statements such as duty to comply are removed. After all, compliance with the law is always required. Multi-employer worksites. On multi-employer worksites, new prime contractor provisions allow for more flexibility, making it easier for more complex worksites to meet their legislative requirements. Prime contractors are still mandatory for multi-employer worksites in construction and in oil and gas, or when ordered by an OHS director. Multi-employer worksites in other industries can voluntarily designate a prime contractor. If a multi-employer worksite has a prime contractor, a Joint Health and Safety Committee, HSC, or Health and Safety Representative, HS representative, is not required. However, on these sites, the prime contractor must designate a health and safety contact to ensure employer and worker cooperation and address matters that an HSC would otherwise be responsible for. If a multi-employer worksite has no prime contractor, they are still required to have an HSC if there are 20 or more regularly employed workers at the worksite, or an HS representative if there are 5 to 19 regularly employed workers at the worksite. HSC and HS representative. There are updates to the HSC and HS representative requirements. The Act keeps the numerical threshold the same. An HSC is required for employers with 20 or more workers. An HS representative is required for employers with 5 to 19 workers. However, the calculation of the number of workers for deciding when an employer requires an HSC or an HS representative is simplified. The Act requires that regularly employed workers are counted towards the threshold. The new requirements are simpler and allow for more accuracy when dealing with the seasonal demands, workforce disruptions, volunteers, or short or irregular shifts. Volunteers don't need to be counted when determining the number of regularly employed workers for HSCs and HS representatives. However, volunteers are still workers with all the same rights and protections under OHS legislation, and they are allowed to participate in an HSC or as an HS representative at the worksite. HSCs and HS representatives still have duties defined in the Act. The receipt, consideration, and disposition of concerns respecting the health and safety of workers. Participation in the employer's hazard assessment. Making recommendations to the employer respecting the health and safety of workers. Review of the employer's worksite inspection records. Other specific requirements regarding HSCs and HS representatives are moved to the OHS Code. Health and Safety Program. As before, a health and safety program is required when an employer has 20 or more workers. The calculation of the number of workers for deciding when an employer requires a health and safety program is simplified. Only regularly employed workers are counted towards the threshold. Please note that volunteers are included in this count, which is different from counting the number of regularly employed workers for HSC and HS representatives threshold. In the 2020 OHS Act, health and safety programs no longer have the required elements, but they still need to satisfy the definition of a health and safety program. Specifically, a coordinated system of procedures, processes, and other measures that is designed to be implemented by organizations to promote continuous improvement in occupational health and safety. Removing the prescribed elements provides flexibility for employers and workers to tailor programs to their individual workplaces. The Bulletin Health and Safety Programs offers some foundational elements to consider when developing and implementing a health and safety program. You can find this publication on the OHS resource portal. Right to refuse dangerous work. The worker's fundamental right to refuse dangerous work is unchanged. However, what constitutes dangerous work was not previously defined. In the 2020 Act, the use of the new term undue hazard clarifies that work refusal are appropriate if there is a serious and immediate health and safety threat. Examples of undue hazards include sudden infrastructure collapse that results in an unsafe physical environment, a danger that would normally stop work, such as broken or damaged tools or equipment, or a gas leak. Other changes streamline the work refusal process. When exercising their right to refuse, workers must, as much as possible, ensure their work refusal doesn't endanger anyone else. This new requirement is consistent with the internal responsibility system. Also, to make the work refusal process easier to follow and support effective engagement from all worksite parties, steps are streamlined. The HSC or HS representative, although appraised of the situation, does not need to actively participate in the work refusal inspection. Section 17 of the Act describes the steps that workers and employers must follow in the work refusal process. See the bulletin Right to Refuse Dangerous Work on the OHS resource portal to learn more. Disciplinary action complaints. Workers are still protected from disciplinary actions for complying with the OHS law, and there continues to be a reverse onus on employers to show that the disciplinary action taken was for reasons other than compliance. New to the 2020 Act is that workers who are part of a collective agreement must resolve complaints through their collective agreement process. Workers who aren't in a collective agreement can make a complaint to the OHS officer. This change gives one avenue of complaints for every worker, allowing OHS to focus resources on complaints from workers who do not have another option. When a non-union worker makes a complaint to an OHS officer, the complaint must be filed within 180 days of the disciplinary action incident. Officers can refuse to investigate a complaint if they find the complaint is without merit, or is frivolous, trivial, vexatious, filed with improper motives, or otherwise an abuse of the process. Workers can request an OHS director review an officer's refusal to investigate on these grounds. Review the bulletin Disciplinary Action Complaints on the OHS resource portal for more details. Acceptances and approvals. The 2020 Act has simplified the request process for acceptances and approvals. To learn more about the process, read the bulletin Applying for an OHS Acceptance or Approval, available on the OHS resource portal. Allowances are now also included in the Act. Allowances give OHS directors the flexibility to update legislative requirements if they lag behind advances in technology or processes or because of exceptional circumstances, as long as no person's health or safety are materially affected by the allowance. Reportable incidents. Prime contractors, or if there is no prime contractor, employers continue to have the responsibility of notifying OHS of reportable incidents. This includes reporting serious injuries, illnesses, and incidents to OHS as soon as possible. They also need to investigate the incident and prepare a report. The 2020 Act clarifies that these reportable incidents include where a worker is, or is likely to be, hospitalized as a result of their work. With radiation legislation incorporated into the OHS Act, radiation overexposure is now also included as a reportable incident. Reporting of potentially serious incident remains compulsory. Potentially serious incidents. The amended Act clearly defines potentially serious incidents. Section 33(5) of the Act gives the two criteria that define a reportable potentially serious incident. These are that the incident had a likelihood of causing a serious injury or illness, and there is reasonable cause to believe that corrective action may be needed to prevent reoccurrence. Note that a potentially serious incident is not limited to workers and does not require the occurrence of an injury or illness. For potentially serious incidents, the Act now allows for a one-step process where investigation reports are submitted once completed. There is no initial reporting required. These new requirements allow for more focused investigations and less burden for prime contractors and employers. Potentially serious incidents report information is for education and preventive purposes only and not for enforcement purposes, except in cases where the report indicates a current or ongoing serious health and safety concern. Read the bulletin Incident Reporting and Investigation for more detail. OHS Officer Authorities. The new Act gives more flexibility for OHS officers, giving them discretion when issuing orders and how they confirm worksite party compliance with orders. These changes increase clarity and give officers flexibility in addressing compliance issues, allowing enforcement to fit the situation. The Bulletin Roles and Duties of Alberta OHS Officers provides details on OHS officer authorities. Other OHS Act updates include appeals. By removing the requirements for an OHS director's review of compliance, stop work or stop use orders, or work refusals, worksite parties can now appeal directly to the Alberta Labour Relations Board, ALRB, streamlining the appeals process. Notifiable diseases are no longer part of the OHS regulation. The Director of Medical Services now maintains and updates the list of notifiable diseases. OHS legislation reviews. Instead of the OHS Act having a review every 5 years, the 2020 Act allows the Minister to request a review of the OHS Act anytime, with no more than 10 years between reviews. The OHS Code Review Plan must be published every 3 years. The updated requirements allow for efficient regulation but still commit the government to keeping the Act and Code current. Thank you for viewing this webinar. If you have any questions about the 2020 Act highlights, call the OHS Contact Center at 1-866-415-8690. In Edmonton and surrounding area, call 780-415-8690. Help us improve our webinars. Please fill out a short survey and give us your feedback. The link to the survey is on the YouTube page below the subscribe button.